Masechet Shevuot Daf Mem Chet. Amar lechem vani ten li bedinar perot vechule. The next part of the Mishnah, let's go back to the Mishnah so we can see the case in full, is when someone tells a storekeeper, please, I want to buy a dinar's worth of fruit. And the storekeeper gave him the fruit. And then the storekeeper says, okay, now pay me the dinar. And the customer says, oh, I already paid it to you. In that case, the customer will have to make a vow that he already gave it to him, and then that's it. He doesn't have to pay. If he said, give me the fruit, and the storekeeper says, I already gave it to you, and you took it home, then the storekeeper is the one that has to make the vow. That's all Tanakama. However, the Rabbi Yehuda says, whoever has the fruit in his hands, he has the advantage. So therefore, according to the Rabbi Yehuda, in the first case, where the customer received the fruit already, the customer does not have to make a vow because he already has the fruit. So let the storekeeper prove that he didn't get the coin. The assumption of the Rabbi Yehuda is that the storekeeper would not give the fruit to the customer unless the customer first paid. Okay, that's case number one. And so we have a Braita that clarifies Rabbi Yehuda's position. Tanya, Amar Rabbi Yehuda ematai. Rabbi Yehuda says, when do I think that the customer does have to make a vow? Even Rabbi Yehuda would agree with Tanakama in the following case. Bizman she'perot tziburin munachin shnehen orelin alehen, aval hifshilan bekupato lachorav, hamosim achavero alav hare'aya. If the fruit is collected, stacked up, and in front of both of them, it's on the counter between the customer and the store owner, and each one saying, I gave you the coin, and the store owner says, no, you didn't give me the coin. In that case, the customer can take a vow that he gave the coin and he can take them. That he would agree. However, if the customer already put the basket of fruit on his back, so that's it. It's in his possession. And we assume that the store owner would not let him take it unless he got the coin first. And therefore, if he already has it on his back, then we assume that the customer paid, and the store owner, if he wants to get it back, claim something, he would have to bring proof. All right, next case, Amar l'shulchani ten li. So this is a similar case, except not a storekeeper and a person buying fruit, but rather a money changer. And the customer says, please give me change for a dinar. I want small coins. And he gives him the small coins. And then the money changer says, okay, now give me the dinar, give me the large coin. And the customer says, I already gave it to you. In that case, the customer needs to swear, and then he will not pay. The Rabbi Yehuda argues in this case, no, a money changer is not going to give out change until he first takes the dinar. Like if you go to a bank today with a $100 bill, first you give them the $100 bill. Then they will give you change. They're not going to give you change first and then ask for it. And since the customer has the change in his hand, therefore we assume that the money changer already got the coin. Now the Gemara asks, why do we need both of these cases? They seem to be saying the same thing. Usericha diashminan hakamaita behach ka amri rabanan mishum de pere abdi demir kebe. If I only had the first case regarding the fruit, I would say that's where Rabbanan say that the customer has to make a vow, because it definitely is possible that the storekeeper would give the fruit before getting the money, because fruit is going to spoil. And so he wants to just unload it, and he'll figure out and get the payment later. So yes, it happens that a storekeeper would give the fruit to the customer and come back later, whatever, when you can pay. And therefore, when he comes and says, hey, you never paid me, it's believable, it's possible, and we make the customer vow. He doesn't want to keep the fruit with him for a long time. But in the second case regarding the money changer, coins don't rot, and therefore, in that case, if the money changer is not going to give change unless he gets the big coin first, because I'll wait. I don't want to take a chance and have to run after you. So the fact that he gave I might think that the fact that he gave the change means that he for sure got the big coin, and so the customer should not have to make a vow at all. I might think that he would agree with Rabbi Yehuda. And so therefore I need the first case to teach me that not so. It is possible that sometimes money changer, he just wants to count it out and give it to him, and then he asks for the coin later. So even in that case, the customer has to make a vow. That's why I need both of them that's why I need the second one. And if I had only the second one, then I would say, Rabbi Yehuda thinks that you can trust the customer and know that he gave the coin in the case of money changer, because for sure a money changer would not give change unless he got the coin. And that's where the Yehuda says that the customer does not have to make a vow. But if I didn't have the first case, I would assume that Rabbi Yehuda might agree with Rabbanan in the case of fruit, because a store owner wants to get rid of the fruit because otherwise it's going to spoil. And maybe he would give it without getting the payment first. And so Rabbi Yehuda might agree with Rabbanan in that case, that the customer has to make a vow. I might think that. So that's why I need the Mishnah to teach this case as well. Siricha, that's why I need both of these cases. The next part of the Mishnah says, "Keshem she'amru apogem et ketubata v'chule v'chen yetumim lo yipareu." Let's look at the Mishnah inside to see the full context. The Mishnah says that just like the law is that a woman who lowers the status of her ketubah by admitting that it was partially paid, if she wants to collect the rest of it, she has to make a vow. So too, and it gives a list of other people that also need to make a vow in order to collect. And then it adds, v'chen hayetomim, also orphans, if they want to collect a loan that someone owes them, they have to make a vow. The Gemara will discuss in what circumstances do the orphans have to make a vow. But then it gives us the language of the vow that the orphans make. And they say, Shevuot shelo pekadanu abba, oath that our father did not tell us on his deathbed that we should not collect the money. V'lomar lanu abba, nor did he say to us that it was paid, nor did we find among his documents that this was paid. So they have to swear that as far as they know, this was not paid. So this is a more limited vow. If the father were alive and was collecting it himself, in such a situation where he would have to make a vow, the father's vow would be, you owe me. I know for sure that you didn't pay. The orphans cannot say that expansive language that we know for sure that it wasn't paid. All they can say is that as far as we know, based on what our father told us, and what we found in his documents, that you owe. Okay, so let's see the circumstances of this case. Miman, who are these orphans collecting from? Ilema milove, if they're collecting directly from the borrower is alive, then why should they have to make a vow? The father would collect without a vow, assuming that the father has a loan document. If he doesn't have a loan document, that's a whole another situation. Then how could he collect at all? So the father has a loan document, so he can collect if he would be able to collect from the borrower himself without a vow. So the father died of the lender, so the orphan should be able to also collect without a vow. Why should we impose a vow on them? So what does that mean? So when can what case is the Mishnah talking about where the orphans have to collect with a vow? We're talking about where orphans of the lender are collecting from orphans of the borrower. And in order to collect, anyone who collects from orphans of the borrower, to extract money from orphans, anyone has to make a vow. And that's what this Mishnah is talking about, where the orphans of the lender have to make a vow to collect from the orphans of the borrower. Rav Ushmel Damre Tarvayu. We already saw this on the previous stuff, but this is actually the original place. Lo shanu ela shemet malveh bechaye loveh. Rav and Shmuel agree that this Mishnah that says that one has to make a vow is only true where the lender dies first while the borrower is alive. Since the lender died first, then the orphans would be able to collect from the borrower himself and without a vow. But then, before they get a chance to collect, the borrower dies. Now, since they're collecting from orphans, just like anyone who collects from orphans, they have to make a vow. And so, yes, that's the case where they would make a vow. However, aval met loveh bechaye malveh, kevan nitchayev malveh libnei loveh shevuah, v'nadam morish shevuah lebanav. But if the borrower died first, so now the lender is alive, the lender, in order to collect from the orphans, would have to make a vow. So that vow already exists, and that is a expansive vow, where the father would say, I know for sure that this was never paid. Then the lender dies without having collected it, and now that vow, their obligation to make that vow in order to collect, will revolve upon the children. But the orphans cannot make the expansive vow because they can't say for sure it was not paid. All they can say is, as far as we know, based on what our father told us. So since there is already an obligation to make the expansive vow while the father was alive, and now the father's not around to be able to make that vow, and the orphans cannot make that vow either. So what can you do? The orphans of the lender now are not able to collect. So this is the law of Rav and Shemuel, that when the Mishnah taught that the orphans collect from other orphans only with a vow, that is true that they can collect with a vow only in the case where the lender died first. And so now you have the lender's children, and they would be able to deal with the borrower, but the borrower died. So now this is a vow that becomes due while they're orphans, so they can say the more limited one and collect it. However, if the borrower died first, then there's already the larger, more expansive oath that the lender himself would have to make, and that cannot go to the children, and so they cannot collect at all, according to Rav and Shemuel. Now this question was asked to Rabbi Elazar. What is the nature of this oath that the orphans of the lender are making? What is this oath? And he said, Shalach lehu yorshin nishba'in shevuot yorshin v'notlin. And Rabbi Elazar said that the orphans of the lender can make their vow, the more limited vow, the one that we read in the Mishnah, and they can collect at any time, in either case. And he made no distinction between who died first, which would mean even if the borrower died first, and yes, true, now the father would have to make the expansive vow, but if the lender died, so the orphans can't make the more expansive vow, so they make the more limited vow, and they can collect. So according to the Elazar, the orphans of the lender can collect with a vow in both cases. He disagrees with Rav and Shemuel. Shelachu habimeh Rabbi Ameh Amar kula hay shalchi la ve'azli I ashkechinan bat ha'ama mila shalchinan lehu. And this same question, same case, was sent to Rabbi Ameh to get his opinion. And Rabbi Ameh said, you keep sending me the same question. If I figured out something or heard something, wouldn't I tell you? Every so often you keep asking me questions about this. I don't have any new information. But then he says, Ela amar Rabbi Ameh, ho'il ve'atali adan nema bah milta. But now, actually, since you asked again, you know what? I do have something to say about this. I'm going to make the following distinction. Amad bedin umet, kevan nitchayev malveh libnei loveh shevuah, ven adam morish shevuah lebanav. It depends on whether they went to trial before death or after death. If they went to trial first, and then the lender died afterwards, in that case, I would agree with Rav and Shemuel, because in that case, the lender already became obligated to make the expansive vow to the orphans of the borrower, and once that lender dies, he cannot bequeath that vow to the orphans, because the orphans of the lender cannot say that expansive vow. In that case, I would agree with Rav and Shemuel. However, lo amad bedin umet, yorshin nishba'in, shevuot yorshin ve'notlin. If they did not go to court yet, the lender did not take the orphans to court, and the lender died, so the borrower died, and then the lender died, and they didn't go to court yet. In that case, I would agree with Rabbi Elazar that the orphans of the lender can make the more limited vow, and they can take it because the father was not yet obligated to make a vow because he didn't go to court yet. And so there was not yet a vow hanging there to be bequeathed, but rather it's a new vow that the orphans are taking upon themselves when they take the other orphans to court. So that was the opinion of Rabbi Ameh. Matkif la Rav Nachman atu bedina kamechayeve le Shevuot meidana dishchib love ichayab le malve libne love Shevuot. Rav Nachman disagrees. What is it, going to Bet Din? Is that what creates the obligation to make a vow? Just because you go to Bet Din, that's when you have to start? That's not true. It's from the moment that the borrower dies. Already, the malveh, if he wants to get paid, is going to have to make a vow to the orphans. In other words, it's created automatically. It's not triggered by going to Bet Din. You just might have to go to Bet Din to enact it, to make them pay. But the obligation for the vow is independent of Bet Din, and therefore, Rav Nachman disagrees with the distinction of Rabbi Ameh. Now, he disagrees with the distinction, but what does he actually think himself? Ela amar Rav Nachman, ita lidrav u'dushmoel ita, ileta leta. Rather, Rav Nachman says, no, you can't split the difference and say in some cases it's like Rav and Shmuel, some cases Rabbi Elazar. Either you agree with Rav and Shmuel all the way and say that the orphans, in that case, cannot make a vow and collect. That's it, they lost it. Or you disagree with Rav and Shemuel and you say that the orphans can make a vow and collect in all cases. Alma mesapik. So now, what are you trying to say? That Rav Nachman was unsure about this? If he's unsure, well, he has to pick one or the other. He's not sure, that's why he's saying this. V'ha'amar Rav Yosef bar Minyomi abad Rav Nachman ubada yachloku. But Rav Yosef bar Minyomi said, this we saw in the previous daf, that Rav Nachman had a case like this come before him, and he said split the difference. So how could he say split the difference if he thinks that either you have to follow Rav and Shmuel or not, so you have to pick one or the other, and either there's a swear and collect, or you can't swear and don't collect, all or nothing. Why did he say split it? Lidvarav de Rabbi Meir kamar vele la sebira le. Rather, Rav Nachman, when he said either you follow Rav Nachman or not, it's all or nothing, that was a comment only according to Rabbi Meir. If we remember back in the Mishnah, the Rabbi Meir says Chazra Shevuot limkoma. If neither party can make a vow, then it returns to its place. And we wondered, what does that mean? And Rav and Shemuel say it goes back to Sinai, meaning no one makes a vow. So if you follow Rav and Shemuel, here's a problem, nobody can make the vow, so they don't make the vow and they cannot collect. And the sages in Israel said, oh, no, it goes back to the original person who was supposed to make it, and one can make the vow and collect. So that's what Rav Nachman meant when he says, well, you have to follow them or not follow them, and all or nothing. That was within the opinion of Rabbi Meir. But Rav Nachman was just saying that theoretically, because he himself does not agree with Rabbi Meir, but rather agrees with Rabbi Yosef, who says that you split it. And that's why he ruled that one splits it. The Gemara now presents a series of challenges against the ruling of Rav and Shemuel. Here's the first one, Mativ Rav Oshaya. Meta Yorsheha Maskirin et Ketubata ad 25 shanim. So you have a married couple and she has a ketubah, and then he dies. So she technically can go to the orphans, his sons, and collect the ketubah. But let's say she doesn't do that, and in the meantime she dies. So the ruling of this Mishnah from Masechet Ketubot is that her heirs have to come and collect and mention the ketubah before 25 years are up. After 25 years, that's it. We say, why didn't you come before that? We see here that the heirs of the mother, who is the one collecting, can go to the heirs of the father, who have the estate, and collect, and there's no mention of having to swear. So we see that they can make a swear, even though this is a case where you could call it the borrower, the one who has to pay, that's the husband, died first. And so once he dies, then the mother, since she's collecting from orphans, if the mother was around, she would have to make a vow to collect from orphans. Now, she died, and according to Rav and Shemuel, the orphans of her orphans or heirs will not cannot take that vow and therefore cannot collect. But here it says they can collect. So how can Rav and Shemuel explain this? And the answer is we're talking about a case where the mother made a vow before she died. So the husband died. She has a right to collect from the orphans with a vow. She makes a vow, but she didn't yet collect, and she died. And now the orphans, they're okay because they don't have to make a vow because the other mother already made a vow. And that in that case, Rav and Shemuel would agree that they can collect without a vow. Next challenge. Tashema. Nasa rishona umeta. Nasa sheniya umetu. Sheniya v'yorsheha kodmin l'yorsheha rishona. If you have another Mishnah in Ketubot where a man marries a first wife and has children with her, and then she dies. Then he marries a second wife, and then he dies. Now, the second wife deserves to get her ketubah from the orphans from the first wife. So if she would do that, she would have to make a vow because she's collecting from orphans. But what if the second wife then dies also? So Sheniya ve'yorsheha, the orphans from the second wife, can go ahead and the payment of that ketubah takes precedence over the ketubah of the first wife, and so the orphans of the second wife can go and collect from the orphans of the first wife, and the point is without a ketubah, even though their mother, while she was the second wife, while she was alive, if she was going to collect, she would have to make a vow to the orphans that she wasn't paid yet. But now she died, and now we say that the orphans can collect without a vow. That goes against Rav and Shemuel. And the answer is, Hachinameh shenishbe'a umeta. This is also talking about a case where that second wife made a vow while she was alive that she got no payment, but she didn't. But then before collecting the payment, she died, and that's why Rav and Shemuel would agree that in this case, the orphans of the second wife can collect from the orphans of the first wife, the orphans from the husband who have the estate, and can collect that without a vow. Next challenge against Rav and Shemuel, Tashema, aval yorshav mashpe'in ota, ve'et yorsheha, ve'et haba'in birshuta. Mishnah in Ketubot teaches that if a husband, at the time that he gets married, makes a stipulation with his wife, listen wife, when you come to collect your ketubah, you will not have to make an oath. Not you and not your heirs. If you're coming to collect from me, then he's doing her a nice favor that whatever the case is, she will not have to make an oath, so she can easily collect her ketubah. Well, that oath will work if it's the husband himself who is paying. However, if the husband dies, then his heirs can force the collector to make a vow. Ota, whether that be the wife herself, if the husband dies and the wife comes to collect from orphans, then she has to make a vow. Or her heirs, that's orphans collecting from orphans, would collect with a vow, or anybody else who comes as her representative. And so this is a challenge against Rav and Shemuel, because here it says that the orphans can collect from the orphans with a Shevuot. But Rav and Shemuel said that they cannot collect, not even with a Shevuot. Amar Rav Shemaya listadin katane ota be'almana ve'yorsheha bigrusha. Rav Shemaya explains that when this Mishnah here says ota ve'et yorsheha, it's not talking about exactly the same case. When it says ota, that she can collect, although she'll have to make a vow, that's talking about when she was widowed. So in fact, the husband dies first, and she wants to collect from orphans. She has to make an oath, but she can make an oath. She knows, and she can say for sure, I did not collect any of the ketubah, and then she can collect from the orphans. But when the Mishnah says ve'et yorsheha, that her heirs can collect with a vow, that cannot be talking about a case of a widow, because that would mean that the husband died first, and she then would have to make an oath to collect from the orphans. But if she didn't collect in her lifetime and then she dies, then the heirs would inherit the oath, but they can't make that oath because they can't say for sure whether the mother ever received any amount of the ketubah or not. And then that would fall under the problem with Rav and Shemuel, and they would not be able to collect in that case. So when it says Yorsheha, it's not talking about a case of a widow, but rather a divorcee, where she got divorced while her husband was alive. Obviously, you can only get divorced while your husband is alive, and at that point already, she could collect her ketubah from the husband. She didn't collect it yet. Then she died. So her heirs can collect from the husband, who is still alive. And they would be able to collect from the husband without a ketubah. And then the husband dies before they get to collect. In that case, they can make a regular vow, a vow of orphans, that as far as they know, there was no collection of the ketubah, which they can make, and then they can collect from the orphans that way. And that would be consistent with Rav and Shemuel. Mativ Rav Natan bar Hoshaya, Yafe koach haben mikoach ha'av, shaben goveh ben bishvua ben shelo bishvua, ve'av eno goveh ela bishvua. Hechi dameh, demet loveh bechaye malveh. So Rav Natan bar Hoshaya is going to bring another challenge against Rav and Shemuel from a Baraita, who says that the power of a son is in some cases greater than the power of a father, where the son can collect alone, both with a vow or without a vow, in a case where the father can only collect with a vow. Now, what case is this talking about? In the case where the borrower dies in the lifetime of the lender. Since the borrower died first, if the lender himself wants to collect from the orphans, he will certainly have to make a vow. So that's what it means, that the father can only collect with a vow. And yet, that there are cases where yet the son can collect, sometimes with a vow and sometimes without a vow. What are those cases? Bishwa, Shevuot, Yorshin. How can they collect with a vow? Well, they can make a vow of orphans. Here is the challenge to Rav and Shemuel, because this would mean that the loveh, the borrower, died first, and the loveh, he could collect with a vow. But then he dies before he collects, and although he would have had to make a vow, we allow the orphans to make their vow, even though it's not the more expansive vow. They can't inherit the father's vow, but they can make their own vow that as far as they know, it was not collected, and they can collect. And there you go. This is against Rav and Shemuel. Okay, before we answer the question, let's just finish the Baraita, that sometimes a son can collect even without a vow. That's like the opinion of Rabban Shimon ben Gamliel in the Mishnah, who says that if there are witnesses who heard the father say on his deathbed that this note has not been paid, then the sons can collect even without a vow. So yes, that as a power that the son would have, that even the father wouldn't have. Okay, that's that case. Anyway, the challenge to Rav and Shemuel is from this case where the heirs, the sons of the lender, can collect as long as they make a vow, even though the father already had to make a vow. And we don't say that they cannot inherit. They can inherit the father's more expensive vow, but they can make their own vow. Amar Rav Yosef, Hamaneh bet Shammai hi damre shetad ha'omed ligabot kegaboi dameh. Rav Yosef says, the author of this Baraita is Bet Shammai. Bet Shammai are of the opinion that a loan document that is ready to be collected, it's as if it's already collected. You can treat the promissory note almost like cash. You can buy and sell with it, kind of like a check that you can endorse over to someone else. And so even though it wasn't technically collected, we consider it as if it's already collected in the father's lifetime. Since it's considered already collected while the father was alive, so then the sons can simply inherit the monetary value of that loan document itself, because it's like it's already collected. It's like especially if it's a loan, a document, so there's a lien on that land. So technically, that land belongs to the father because he can go and take it. So when the father dies, the sons are just inheriting that piece of land. Okay, they have to actually go and technically transfer it, but it's considered already transferred, already in their possession, and that's why they can collect it but just by making their own vow. But that's the opinion of Bet Shammai, and so it presents no challenge to Rav and Shemuel. Ikla Rav Nachman lesura. ולגבי רב חיסדא ורבא בר רב הונא, אמרו לתאמור נעקרה לה דרב ושמואל. One time, Rav Nachman went to Surah, and Rav חיסדא and Rabba bar Rav Huna, who lived in Surah, went to see Rav Nachman, who came to their city. And they told him, let the master come and let us uproot the law of Rav and Shemuel, because it's a big problem, this law of Rav and Shemuel, because they say that these orphans cannot collect, even if they make a vow, they cannot collect. It's very difficult, because then they're losing out on money, and so this is their law is difficult. So let's uproot it. אמר להו, איך פלי ואתה כל הנה פרסה למי אקרא להד רב ושמואל. Rav Nachman says, what, you think I traveled all this way, all these parsangs, just to uproot Rav and Shemuel? I don't want to do that. Ela havu de la losif ala. It's sufficient if we do not add any extensions to the law of Rav and Shemuel. We will leave it limited to the cases where it applies, and that's it. And that's okay, we can live with that. כגון מאי דאמר הפאפא, הפוגם את שטרו ומת. יורשין נשבעין, שבועת יורשין ונוטלין. What would be an example of what Rav Nachman meant when he said we should not add to the ruling of Rav and Shemuel? The example would be what Rav Papa said. He said that if someone weakens his document, that's the lender. The lender admits, listen, this was partially paid, but not the rest of it. In order for that lender to collect, because he weakened his loan document, he has to make a vow. Now, let's say that lender dies, and now the orphans want to collect. So Rav Papa says they can collect. They make a vow, and they can collect. Now, you might have thought here that we should extend the ruling of Rav and Shemuel and say, well, the father, he can make a vow because he knows for sure this document was half collected, but the other half was not. And maybe his sons would not be able to make that vow for sure, and since they can't make that vow with as much authority as the father, then maybe they cannot collect at all, even if they vow. That would be an extension of Rav and Shemuel. But Rav and Shemuel did not talk about this case in particular, and therefore Rav Nachman saying, do not extend their ruling, rather say here, as Rav Papa did, correctly, that the heirs of the father of the lender can make a vow that, as far as they know, this was partially collected, but the rest of it is still outstanding, and they can go ahead and collect. Now we'll see a couple of more cases that perhaps would or would not fall into the ruling of Rav and Shemuel. Someone died and left a guarantor. So this is the borrower has a guarantor, and the borrower himself died. There's also orphans. Rav Papa said, maybe in this case, this would be included in Rav Nachman's declaration that we should not add to Rav and Shemuel because there's a guarantor. So maybe the heirs of the lender can go to the guarantor and collect with a vow. Since they're not collecting from orphans themselves, but from the guarantor, so maybe that would be sufficient, and we will not extend Rav and Shemuel's stringency and say that they can't collect at all. That's what Rav Papa was thinking. Amar le Rav Huna bered Rav Yoshua le Rav Papa atu arba la batar yatme azil. But Rav Huna, the son of Rav Yoshua, objected to Rav Papa and said, no, the guarantor only comes after the orphans. You have to go and collect from the orphans first. And if then you can't get payment from them, only then you can go to the guarantor. But as soon as you go to the orphans, the law of Rav Papa, Rav and Shemuel, will kick in, and they can't collect because they can't make a vow themselves, so they cannot collect from the orphans, and therefore they cannot collect from the guarantor either. And so we do have to apply Rav and Shemuel here. This is not an example of what Rav Nachman said, that we should limit the application of their law. So let's try another one. Someone died, and his closest heir was his brother. And the father died, but the father had to make a vow to the borrower's heirs because the borrower died first. But now he died, so now the brother wants to try to collect collect the loan. Sabar Rami Bar Chama lememar hanami dela losif alahu. Rami Bar Chama said, oh, maybe this is a good example of Rav Nachman said that we should not extend the stringency of Rav Nachman to this case, of Rav and Shmuel to this case, because here, well, it's the brother who wants to collect, so maybe we allow the brother to collect and to make a vow and collect. Amar le Rava, mali shelo pekadani abba, mali shelo pekadani achi. But Rava objected to that and said, there's no difference between the vow that sons make to say, my father did not tell me that this was paid, or the brother saying the same thing, my brother did not tell me that this was paid. Both of them can make the more limited vow, but neither of them can make the more expanded vow that the lender himself can make. And therefore, since we're going to apply Rav and Shmuel to the son, then you have to apply the same stringency to the brother. And unfortunately, we're going to have to extend Rav and Shmuel also to the case of a brother. Amar Rav Chama, Hashta delait mar hilchata, lo kerav ushmuel velo kerebi el azar, hay dayana da abad, kerav ushmuel abad. Da abad kerebi el azar abad. Rav Chama says, there is no clear halacha that was stated, not that we follow Rav and Shmuel, who's more stringent, and says that orphans cannot collect not even with a vow, nor is there a clear halacha decided like Rabbi Elazar, that the orphans can collect in all cases if they make a vow. Since there's no clear halacha that was decided, if a judge wants to give a ruling in accordance with Rav and Shemuel, that's a valid ruling. And if a judge wants to follow Rabbi Elazar, that's also a valid ruling. You can't come afterwards and say, oh, this was a mistaken judgment, reverse it. No, the judge has leeway to pick one or the other because there is no clear-cut halacha. Amar Papa, hay shetara deyatme la mikra karinan le vela agboye magbinan be. Agboye la magbinan be dilma sibirelan kerav ushmuel umikra la karinan le dehay dayana da avad kerebi Elazar avad. Rav Papa says, if there is a loan document that belongs to orphans in a scenario like this where the borrower died first and then the lender died, so now the orphans of the lender have this outstanding loan document, Papa says we should not tear it up, nor can we use it to allow them to collect. We cannot use it to allow them to collect because perhaps the halacha is like Rav and Shemuel, who says that even if they make a vow, they cannot collect, so we can't let them collect. So then rip it up, right? Why should we keep it around? No, we don't rip it up either, because if there is a judge who decides like Rabbi Elazar, then he will be able to enact it. So we leave it there, and then if and when it comes to a court and the judge decides one way or another, so they need to have it just in case they will rule like Rabbi Elazar. Hahu dayana davad ke Rabbi Elazar. There was a judge that issued a ruling in accordance with Rabbi Elazar and allowed the orphans to make a vow and collect. Hava surbam rabanan b'mateh amar le aitina igarta mima'arba dele tilchata kerebi Elazar. There was a Torah scholar there in the city who heard about this judge, and he said, I'm going to Eretz Yisrael, and I'm going to bring you a letter from there that says halacha is not like Rabbi Elazar, and you cannot do that. You don't have the right to judge a case in accordance with Rabbi Elazar. Amar le lechi taitev. So the judge said, okay, go bring it. Ata lekameh de Rav Chama. Amar le hay dayana abad ke Rabbi Elazar abad. And that Torah scholar came to Rav Chama hoping that Rav Chama would give him such a letter. But Rav Chama says, no, it's not true. If a judge wants to rule according to Rabbi Elazar, then he has the right to do so. You cannot void the judgment. That is a valid ruling. Ve'elu nishba'in, the Mishnah continues and says, the following is a list of people that have to make an oath even when there's no claim against them, and it gives some examples like partners, where one partner can make the other vow that he didn't steal anything. So the Gemara asks, are we dealing with fools? Are you saying someone's just going to go around and make a vow just randomly? I make a vow I didn't steal anything, without anyone making a claim against them, to just randomly make vows that they didn't steal? I mean, that's a foolish thing to do. Hachi ka'amar ve'elu nishba'in shelo betanat bari ela betanat shema hashutafin varisin. No, that's not what the Mishnah means, that they just randomly make vows. Rather, here means that the following have to make a vow even though the other side doesn't have a definite claim. He doesn't know for sure, you stole 100 zuz. I know for sure. He doesn't know for sure. He says, maybe you stole 100 zuz. I'm not sure, but it seems possible. I want you to make a vow. Then he can make the other person vow, even though he doesn't have any proof, he doesn't have one witness or anything like that. Esei d'Rabbanan, to protect these partnerships or sharecroppers. Tana, ben bait she'amru, lo shenichnas v'yoseh beraglav, ela machnis lo po'alin, u'mosi lo po'alin, u'machnis lo perot, u'mosi lo perot. One of the items on the list was ben bait, someone who's a member of the household. So what does that mean? It's not someone who just walks in and out regularly like a family would or a friend would. It's not just a good friend who walks in and out of the house and stays around all the time, but rather it's someone who manages the estate. Someone who hires labor, fires laborers, gathers produce, sends out produce because he's managing it. So he's basically in a partnership, an important manager in the house. That person is like a partner, and the owner can ask that person to make a vow, even if it's only on a possible claim. Now, how come in these cases one can make them take a vow, even though the claimant is not really sure that they stole anything? Mishum de maruba hetera, because psychologically, all these cases, these people tend to justify themselves taking a little extra for themselves because they figure, look, I'm putting a lot of work into it. We're partners, or I'm a sharecropper, or I'm a manager of the house, or I'm a manager of an estate for orphans, and I'm putting a lot of work into it, so I can take a little extra for myself, because they justify that. But they really can't do that. So, but since it happens often, that they might justify it, therefore, the other party can say, I suspect that there's $100 missing here. Can you make a vow that you didn't take it? And then he would have to make a vow. Amar Rav Yosef bar min Yomi Amar Rav Nachman, v'hu sheyesh ta'ana benayu sheteh chesef. Rav Yosef, son of min Yomi, says name of Rav Nachman, that one partner can only make the other partner take an oath if the claim, although it's an uncertain claim, the claim has to be worth at least 2 silver ma'ah. If he's going to claim just a few cents, that's not sufficient to warrant. This is similar to the law of modeh b'miksat, where we also said that according to Shemuel, the claim of the modeh b'miksat has to be, the initial claim has to be at least 2 ma'ah to warrant a vow. And so Rav Nachman saying that's true here also. Keman kishmuel. So now you're saying that we're following the law of Shemuel of modeh b'miksat and applying it to this also. V'atane Rabbi Chia l'sayoel l'Rav. But Rabbi Chia had a braita that supported Rav. So we shouldn't be following Shemuel. We should be following Rav instead. And Rav says that the amount of the denial has to be 2 silver ma'ah. So we answer, Ema kefirat ta'ana kerav. In fact, yes, that's what Rav Nachman meant to say, that the other partner who's going to make a vow only needs to make a vow if he's denying a claim, and the part that he's denying is at least 2 ma'ah, and that is in accordance with Rav. Chalku hashutafin v'ha'arisin. The Mishnah continues and teaches that if the partners end up splitting the property, or the sharecropper is not working there anymore, then one of the parties may no longer make an indefinite claim to the other and make them take a vow, because they aren't partners anymore. However, the Mishnah adds that if one of the parties does make the other one take an oath for a legitimate reason, for some financial matter that comes up between them, then megalgilin, then we can extend the oath and say, while you're at it, since you already have to take some vow for, I don't know, whatever, modeh b'miksat, then they can add on and say, also, can you make also a vow about another matter? Then they would be able to add on any other matter. Iba'ya lehu. hu, mahu legalgel midrabanan. Now we ask a more general question, but it jumps off this topic. Can you add oaths, extend oaths, if the original one is the Rabbanan? We know for sure that, let's say, I make you take an oath of modeh b'miksat. I claim something and you admit to part of it, so you have to make an oath, mideoraita. Since you're taking an oath mideoraita, I can add on also the Rabbanan oaths that otherwise I wouldn't be able to. That for sure. But what if the original oath is the Rabbanan? Can you add to that? Here's the answer. Tashema. Lava hemenu erev shebi'it umoseh shebi'it nasa lo shutaf o aris. En megalgelin. Ta'ama de lava hemenu erev shebi'it. Achat shebi'it afka'ateh. Hashar shene shavua megalgelin. A Baraita teaches that if someone borrows money from someone else before Shevi'it, now Shevi'it then is going to come and cancel that loan, and then after Shevi'it they become partners, or it becomes one becomes the sharecropper or of the other, and as partners, one of the parties asked the other to make a vow. Now that vow is the Rabbanan. In that case, one cannot add on, also, while you're at it, making a vow, because you're my partner, I want you to make a vow for that loan that happened before Shevi'it. You can't do that. Now, why can't you do that? Well, that's because the loan happened before Shevi'it, and Shevi'it comes and cancels the loan altogether. So there's no reason to impose an oath on a loan that is completely canceled. But we can infer from this Baraita that if it was not before Shevi'it, let's say the loan was in the second year of Shevi'it, and they become partners in the third year of Shevi'it, and there was no independent reason to require an oath for the loan, but now that they're partners, he can require an oath as a partner and can add on an oath regarding the loan as well. So we can prove from here that an oath that is derabanan, which this one is, the between partners is derabanan, you can use that to add on other oaths. So the answer to the question is yes. Is that a good proof? No, this inference is not necessary. Don't learn the inference that you just said, that therefore in other years you could add on vows. Rather, the inference should be a different one, that if the events happen the other way around, if someone were partners or a sharecropper before Shevi'it, and then after Shevi'it, one takes a loan from the other, then they can extend. If there's one will require the other to make an oath because of the loan, which is a deoraita law, then one can extend that and add another oath regarding their partnership. That's what we can learn from here. But we're not learning anything significant regarding the question, because this is a deoraita that's extending to a drabanan, which of course you can do. So there's no proof from here. But we reject this rejection because that is taught explicitly in the Braita that says if they were partners before Shevi'it and then after Shevi'it there was a loan and he's making him take a vow because of the loan which is deoraita, then he can add also a loan because of the partnership. So we already know that case, so we wouldn't need this Baraita to teach it or have something that we would infer from it. We don't have to infer that from this case because that's obvious. Rather, the original inference that we made over here is the correct one. Shema mina megalgalim b'drabanan shema mina. So we learned the answer is in fact yes. Even if the original loan that one requires of someone else is the Rabbanan, you have the rule while you're at it. Since you're already making a vow, you know what? I want you to make a vow regarding some other items. Amar Rav Huna, lakol megalgelin, chutz misachir she'en megalgelin. Rav Huna says we can extend an oath on anyone except for a worker. If a worker comes and says, hey, you didn't pay me, and we said above that he can make a vow and collect. And we do this only to allay the concerns of the employer so he doesn't think that he's being stolen from. But we want to protect the rights of the worker. So now we're not going to give him trouble by making him add more oaths. Rather, no, he doesn't have to have and make any more oaths. He just can make a vow that he didn't get paid and take his money. Rav Chisda amar lakol en mekilin chutz misachir de mekilin. Rav Chisda says something very similar in different words, that we are not lenient for other people. Other people, once they make a vow, then they have to extend the vow to other vows if the other party wants to, except for a worker where we are lenient and we do not make him take other vows. We ask, "My benayu, what's the difference between Rav Huna and Rav Chisda?" They seem to be saying the same thing. And the answer is, "Ika benayu liftoach lo." The difference is whether the court itself will give a suggestion to the plaintiff that, hey, you know what? You're making him take an oath. Why don't you make him take an oath about this and that? So for a non-worker in other cases, we would suggest that the court would suggest that the person should do that and add other oaths. So that's what it means here. According to Rav Huna, we don't do that for a sachir. Sachir en megalgelin. What that means is that for a sachir, the court will not suggest to the plaintiff, hey, while you're at it, why don't you add other oaths? But if the plaintiff comes up with the idea himself, we allow him to do so according to Rav Huna. However, Rav Chisda's language goes a little bit further, that we are lenient, extra lenient. According to Rav Chisda, not only does the court not suggest that the plaintiff add more oaths, even if the plaintiff himself comes up with the idea and said, I want to add on some other oaths, we don't let him, but rather we protect the worker so that he just has to make an oath that he can collect, and that's it. The last, at the end of the Mishnah says that just like the Shevuot law cancels loans, it also cancels an oath if that oath came up because of a loan. There was a dispute about a loan, and then one party had to make an oath because of that, but then Shevuot comes, Shevuot cancels that oath that came from the loan. What's the source? Amar Rav Gidel, Amar Rav, Amar Kera, Vezeh debar Hashemita, Vafilu dibur meshameshet. Rav Gidel says in the name of Rav, because the pasuk says this is the matter of release, and this word could have just said Zeh Shemitah. What do you mean Zeh Devar Shemitah? That even words are canceled, meaning even an oath that one was obligated to make before the Shevuot came, and it was an oath that was prompted because of a loan, Shevuot comes and cancels even that obligation for an oath. Hadran alach kol hanishba'in. Baruch Adonai le'olam. Amen ve'amen.